All right, good evening. Welcome, everybody. Welcome to the 2024 Ruth Wright Distinguished Lecture in Natural Resources. It's wonderful to have you all here. My name is Chris Winter, and I'm the Executive Director of the Getches-Wilkinson Center here at Colorado Law School. And along with the American Indian Law Program, we're very excited to host this program for you this evening. So thank you so much for joining us. Just a couple of announcements up front. After the program, please join us upstairs in the Commons. We'll have a reception, food, and some drinks, and so I hope you'll join us for that. We'll have some Q&A at the end of the program as well, and so I think Zane is over here. He'll have the mic, so feel free to ask some questions afterward, which is a really unique opportunity. And I also wanted to remind you all about the March Symposium, which is focused on public lands. It'll be a 2-day conference here at the law school, October 4th and 5th. So I hope you'll also consider joining us for the March Symposium. We have a really amazing lineup of speakers. So before turning to the rest of the program, I wanted to take a moment to acknowledge that the University of Colorado Law School and the entire University of Colorado campus are on the ancestral and traditional homelands of the Ute, Arapaho, and Cheyenne peoples. And further, we acknowledge the 48 contemporary tribal nations historically tied to the lands that are now called the state of Colorado. So it's a privilege for all of us to be here together this evening. The Getches-Wilkinson Center, for those of you who don't know us, is an interdisciplinary research center here at the Colorado Law School. And here in Colorado, like other places across the West, we all depend on the land, the air, the water, the wildlife, and the natural wonders around us. And so these are the resources that really define who we are as Westerners. They support our physical and mental health. They provide for our local economies. And I believe that our generation will ultimately be judged on what we leave behind of this natural bounty for our kids and their kids. So at its core, our work here at GWC is about promoting the sound management of our natural resources for future generations and also supporting the incredible students here at Colorado Law School who will go on to become the leaders in this work for all of us. We also support the role of the tribes and indigenous peoples in this critical work, and we're very proud to build on the incredible legacy that Professor Getches and Wilkinson left for all of us here at Colorado Law School. Now, one key way we do this is by convening thought leaders to address the most pressing issues of the day, which brings me to the Ruth Wright Distinguished Lecture Series that we're here for tonight. And so in 2018, GWC received a generous gift from the Wright Family Foundation to establish this lecture series in Ruth's honor. And so while a student here at Colorado Law, Ruth was quite active, and she led efforts to preserve Boulder's open space as public land for all of us and to limit the height of buildings in the city so we can all enjoy that landscape. And so virtually all of us here in this room tonight benefited from Ruth's vision and hard work when she was a law student here at Colorado Law School, although we may not appreciate the way that we've benefited from hard work day in and day out. In 1980, Ruth was elected to the Colorado House of Representatives and served as the minority leader in the House from 1986 to 1992. And she's been widely recognized as a champion for the environment and conservation in Colorado. And so we're honored and grateful to be able to recognize her through this lecture series. Now, tonight, it's my distinct honor to be able to introduce Bob Anderson, the Solicitor of the Department of the Interior. Bob is a law professor with extensive experience in American Indian law, public land and water law, and he taught at the University of Washington Law School and directed its Native American Law Center for 20 years. He's also a longtime friend of the Colorado Law School and taught here as a visiting professor before his most recent stint at the Department of the Interior. And on our drive into Boulder from the airport yesterday, I also learned that Bob started out his career as a staff attorney at the Native American Rights Fund and opened NARF's first Alaska office way back in 1984. So Bob has truly had a diverse and varied career. And so as we were talking on our drive in, I soon came to realize that Bob knows virtually everyone who's doing this work, and he's worked on virtually everything. So it's quite an honor to have him here at Colorado Law School. So we're very lucky to have him back, and please join me in welcoming Bob Anderson.
All right, here we go. It's good to be back. I'm really happy to be in Boulder. I always love to come here. As Chris said, I've got an echo here. As Chris said, I started out my career at NARF first as a summer law clerk in 1982, coming out from the University of Minnesota. I'd never been anywhere except across the Canadian border in a canoe, so it was quite an adventure to come to the Boulder area and fly in an airplane for about the first time. And I was one of those people taking pictures of the tops of the clouds as I flew out here for that first summer. And I was really thrilled when, after I graduated, Jeannie Whiting, who's here, called me and said that they were going to offer me a job to be a staff attorney at NARF. And so it was an exciting time for a young lawyer and a great place to start my career. And I always, now that Jeannie's here, I always tell this story when she's in the audience, how I wanted to take 3 weeks off after the bar so I could relax a little bit after law school and studying for the bar. And Jeannie said, well, we've got the St. Louis Ray water case. Bob Pelsiger needs help on that, and you need to get out here and work on that. And it's really, really important. So I rushed out here and got here, and I worked on it, and it was still going when I left NARF. It was still going on in the late 90s when I was Associate Solicitor for Interior Affairs at DOI, working for John Leshy and Bruce Babbitt. And Bob Pelsiger still calls me periodically, leaves me a voicemail because he wants to talk to me about something on San Luis Rey. So, for the young lawyers, we start working on these cases and they never end. Because it's about a river, a flowing river in the water law arena, and there are always going to be new issues cropping up that need to be dealt with. And revisions made due to the changing needs of society. So thanks, Jeannie, for giving me that first job and getting me out here. I'm also really happy to see more NARFers here. John Echohawk out here, who so ably led NARF for over the last 50 years. Thanks for coming along with the members of my solicitor's office team that are here, our regional solicitor, Michael Williams and Phil Lowe in the Rocky Mountain office as well. We've got a great team of lawyers who work in the solicitor's office and serve Secretary Holland. It's really an honor to give the Ruth Wright lecture. I was looking at her biography on the CU website, and I was struck by her long commitment to public service and conservation. And I noticed that she and I share a common interest regarding legal protection for in-stream flows. It says on the website that she wrote a brief about in-stream flow protection, and that's been one of my passions throughout my career that I've worked on, and I'll talk a little bit about that later tonight in my remarks. So thank you, Ruth. I know you're not here, but I appreciate being able to give this lecture in your name. I mentioned NARF and how I got there. I was here for a year in Boulder, and thanks to some of the prompting by David Getches and Charles Wilkinson and John's agreement, we decided to open an Alaska office in 1984. I wanted to send a young guy up there. That was me. I was 27, and a more experienced lawyer was Larry Aschenbrenner, who was a lot younger than I am now. And I remember when I first met Larry, I thought, man, that guy is ancient, And so I was telling the students today, I said, I know what you're thinking as I'm standing up here talking to you, because I was in your shoes a while back. But it was a thrill to move to Alaska, open that office. And I think it's going to have its 40th anniversary coming up here in October. So that's a great office, and I was really happy to have worked there for about 11 years. The Getches-Wilkinson Center and NARF, really bring together some of my favorite people. When I came to NARF, David Getches, who was our founder of NARF, and Charles Wilkinson, who had worked there, were around NARF a lot, working on cases. I got to work with Professor Emeritus Rick Collins on a Solem v. Bartlett Indian law case that ended up being a huge victory for Indian country in the Supreme Court back in about 1984. And that was a real joy. Becoming friends with David and Charles was a great experience. And, throughout my career, they helped me on Alaska matters. They were always available to provide advice to me. They would come out to my conferences at the University of Washington and give presentations. And, we're all around tremendous colleagues. So I really count myself lucky as to have worked with them and been their friend over the years. So David and Charles, we all think about you often and miss you a lot. But let me pivot a little bit to the Department of the Interior, which is where I work now, and I've been there since January 20th. Of 2021. I've got to say, being the solicitor is something I've always wanted to do since I got there in the 90s. I met John Leshy when he was a solicitor and got to know him and Bruce Babbitt working on a case I'll talk about later, the Katie John case out of Alaska that involves some subsistence fishing and continues on in another iteration now in a case that the United States has brought against the state of Alaska. But moving to Alaska was great. Working with the solicitor's office, first as someone trying to get the government to change positions in a case and come over to our side, and then on the inside as the associate solicitor in charge of the Indian law component, then as a counselor to Secretary Babbitt, really exposed me to all the things that the Department of the Interior does, which is a lot. We've got a huge portfolio of matters, and I'm just going to talk about a few of them tonight. But it's a real joy to be able to be at the helm of the solicitor's office and work for Secretary Holland. She's a tremendous inspirational leader. We've had many strong advocates as Secretary of the Interior for conservation. In Indian affairs, even in the Clinton administration was an important component, and we did a good job. But for a long time, Indian affairs had been sort of part of the BIA. They do the Indian affairs, and everybody else, they do Park Service does parks, Fish and Wildlife Service does refuges and the ESA. MMS, now BOEM and Bessie, do offshore oil and gas drilling. BLM used to be known as the Bureau of Livestock and Mining. Now all of these bureaus under Secretary Holland's leadership, carry out their traditional missions, but they also do it as part of her dedication and inspiration to work with Indian country, which is dominant on the landscape in terms of presence in just about every corner of the western United States where we have most of our jurisdiction. And so Secretary Holland, has really inspired her team on the political level and also at the career level to work with tribes to undertake co-stewardship opportunities, which is an umbrella term for the different types of co-management regimes that we work out with tribes under various statutes and regulations that we implement. She stood up the first ever Secretary's Tribal Advisory Committee, which is a group of tribal leaders from around the country that comes in about 4 times a year. We all get called on to go down there and explain ourselves for things that might be well received, but more often are things that they think we could be doing a little bit better. And so that's always a fun experience. And, the one thing about public service at the department is the only way you you don't make someone mad at you is by not doing anything and just hiding in your office. And we don't do that. And so, we get sued every time we do something consequential by one side or the other, or sometimes by both. But, we're adults and we can handle that. And, I like to set an example of, having, rational conversations about policy choices that we made and our legal interpretations. Of course, Congress ultimately has plenary power over public lands and can reverse our decisions, which they do from time to time. We accept that. That's their role. And, we endeavor to follow the statutes and regulations that guide us. Equally important, though, are the internal workings of the federal bureaucracy, the manuals, the instructional manuals, the departmental manual, all this step-down advice that explains the laws, the regulations, and the actual implementation that people who are in the field undertake when they make decisions and consult with the local community, whether they're Indian tribes, ranchers, the grazing community, or those who want to develop oil and gas on our lands. And so that step-down advice is really critical, and it's something that, my team in the Solicitor's office plays a huge role in for all of our bureaus. And I like to say that the Solicitor's office is sort of we're the honest brokers for the department. Everything comes through our office. In D.C., we're set up in different divisions. Somebody does Fish and Wildlife and Parks. That's Sarah Krakoff, professor here at the University of Colorado, and her team. And then we've got others that do the BOEM and Bessie work and the onshore oil and gas development. Natalie Landreth, who we stole from NARF, does our lands work in D.C. And then we have, these regional offices. Michael's head of our regional office here in Denver, and that office serves all the bureaus, and we coordinate. Somehow it happens that we coordinate so that things come to my attention when they need to, either because they're important policy matters, it's a real hot-button issue with a particularly important constituency or a member of Congress, and ultimately, it's my job to advise the secretary, the chief of staff, and other leadership on the policy side about the legal options they have for choosing any particular policy. But the 460 lawyers in my office are the ones that do all of the work in these 16 regional and field offices, and then our central office in D.C. And, the secretary's always thanking me for the work that I do for her, but she also says, but I know you don't do it all yourself. I know you've got a great team, and I say I do. And, they're the ones that carry out all of the functions that the Solicitor's office carries out. But on to the Secretary's influence, again, BLM, Fish and Wildlife Service, Park Service have all entered into co-stewardship agreements with tribes around the country. The department has been aggressive about promoting the use of indigenous knowledge in all aspects of our work, along with Western science. The U.S. Geological Survey has got its own indigenous knowledge policy for implementation. So it's really been we've made great strides in that arena over the last 4 years that we've been in office. The Secretary has begun this federal Indian boarding school initiative that revealed the horrible things that happened during the assimilation era and the termination era of the federal government. She raised public awareness, held a series of meetings called the Road to Healing across Indian country to take testimony, and just went out and sat and listened. And a lot of appreciation from Indian country for that and that work. And she's truly a inspirational leader. I have to give a shout out to the person who really makes it possible for me to do my job. It's Anne Marie Bledsoe Downs. She's the principal deputy, and she's the one that really manages the solicitor's office. You know, I get to work on some really interesting substantive issues, and so does Anne Marie. But she's the one that meets with the regional solicitors every other week. She's the one that makes sure our budget is operating properly. And I just can't say enough about my appreciation for the great work that Anne Marie has done for our office. And then I've got the 6 political deputies that work in the various substantive areas. And we also have bought out a little bit of Professor Kristen Carpenter's time from CU to help us out on some of our international indigenous rights initiatives at the UN and so on. And so it's been great to have Kristen working with us. Finally, if any of you have ever tried to set up a meeting with me or anybody else who was a solicitor over the last 30 years, you would have met Mary Grace Caminetti, who is my executive assistant. And she knows everything about the department. Everyone says when there's some question that no one understands the answer to, everyone says, ask Mary Grace, and she knows the answer. So I couldn't survive without her there to assist me on a day-to-day basis. It's, you know, I'm just going to reflect for a second on, you know, what was going on 4 years ago at just before the election. You'll remember that election. And I had been asked, as I had done several times before, for Democratic potential presidents to be on the agency review team to review what Interior had been doing in the Trump administration and to come up with papers that would make recommendations on what the President Biden's administration should do should he be elected. Kevin Washburn from the University of Iowa, he was a dean there. He was our chair. I was the deputy chair of that committee, and we had a great team of other law professors and practitioners who knew all the different substantive areas that Interior worked in that conducted this review and evaluate and make recommendations for initiatives. And unlike prior efforts, like when John and I were on the 2008 Obama transition team together, we were asked to make recommendations for personnel. And you know, so there were recommendations made up to others. And our current deputy secretary, Laura Daniel Davis, was the lead on that. And you know, identified folks, and you know, I was one of the folks that got recommended to be the solicitor, and went through an internal interview process. And several of us on that team joined the department on January 20th at the inauguration, and it was a real advantage to have been on the agency review team because we knew what was going on in the department. Most of us had been there. We had talked to folks in all the offices. I interviewed every regional and associate solicitor on the career side in the department and talked to the substantive divisions about what was happening. So that was a huge advantage going in on day one to hit the ground running. And we had a lot of directives from President Biden in his early executive orders that I'm going to talk about here in a second to give you a flavor of just what it was like and what we worked on. But first, I just wanted to look up a few statistics to share with you. And I know you all know this about the breadth of Interior's reach in terms of our jurisdiction. And the United States government owns 628 million acres of land in the U.S. It's about 28% of the land in the United States. 190 million of those acres are Forest Service lands, and the remainder are managed by the various bureaus in the Department of the Interior. For those 190 million Forest Service lands, the BLM also manages the subsurface estate. So Phil Lowe and I worked together on an important Forest Service case up in the Badger 2 Medicine area, some leases involving Solonex that we wanted to retire in favor of wilderness. And Phil worked hard to, with us, with the central office, and with the Forest Service to lead the effort to get those leases retired. And the Blackfeet Nation was very happy about that. It was only a single lease in a relatively small area, but it was very important. It showed the need to coordinate with Forest Service, our sister agency, just one of the many things that we do to make life better as best we can. Besides those land-based resources that we've got, we manage the Outer Continental Shelf for oil and gas production, and now, for the first time, for offshore wind production. And so the OCS, I had to look up on the Congressional Research Service to find the size of it, and it's 1.7 billion acres, so it's a huge resource. I mean, most of the activity takes place fairly close into land, and most of the oil and gas production is down in the Gulf of Mexico. But it's a massive resource that we deal with in the OCS through the BOEM and Bureau of Ocean Energy Management. For those of you who don't, we are landlocked here, so it's both, and so that's how we do our offshore work. We were facing when we came into office 4 years ago, fortunately, President Biden had issued a couple of executive orders that told us to do some very specific things. One was to advance clean energy, onshore and offshore. To figure out how to do that, we'd been thinking about that during the transition because we knew that this was going to be a big part of his agenda to conduct a review of current oil and gas leasing operations on public lands that hadn't been revisited for many, many years, and make recommendations about new legislative approaches, and also what else could be done through the regulatory framework to, ensure continued resource production, mostly in the renewable area, and also to make sure that for any oil and gas development that conservation was equal with production, and also that the American taxpayer was getting a fair return on the resources that oil and gas companies were capturing from our public lands. And so that was a big agenda item. On the programmatic side, we have had huge success. BLM's goal was to, permit 25 gigawatts of renewable energy by 2025. They've exceeded that. They've permitted 29 gigawatts of clean energy, enough to power 12 million homes from the public lands. And there are, those renewables are in a mix of geothermal, solar, and other projects in the renewable energy sphere, mostly conducted by BOEM. We've got another 66 clean energy projects in the permitting pipeline, so things are moving well, and that would add another 32 gigawatts to the grid. It's not all easy. We get sued a lot over these geothermal, there's always an endangered species nearby, and so the Fish and Wildlife Service has to take care to ensure that the development can occur with adequate protection for the species. We think we have done that. Others disagree, and so they take us to court. We win some and we lose some, and when we lose, we generally just have to go back and do it again and do it better. So it's all fair play, and it's a great country that we have where somebody who doesn't like what their government is doing can go to court and sue the government. I've done it many times before I came in, and that's the way it is. What's good for the goose is good for the gander. So it cuts both ways. But a lot of success in permitting clean energy projects. We just, in early September, approved our 10th commercial scale offshore wind project. There had been none approved by an administration before that, so we're particularly proud of doing that. It took a lot of innovative work in the Solicitor's office, in our Division of Mineral Resources. We have a tremendous career team that has worked with Travis Anatoine, our political deputy, on developing a legal approach that's resulted in us winning every case every time we've been sued in the offshore wind arena. So particularly happy about that. President Biden set a goal of achieving a capacity of 30 gigawatts of production. We've got 15 gigawatts permitted as of now, and more in the pipeline, so a good thing. More litigation. President Biden in his executive order told us to look at these Arctic refuge leases in Alaska. In 2017, Congress passed a tax act that included a rider that authorized oil and gas production in the Arctic National Wildlife Refuge, which had been protected by Congress. And it was sacrosanct to the environmental groups, but when President Trump came in and had control of both houses, they were able to authorize oil and gas production in the Arctic refuge. The prior team was directed by Congress to start the process of getting to 2 oil and gas sales in the Arctic by the end of 2024. They really rushed the first one through in 2020, took some shortcuts. President Biden's executive order directed us to review the work under the National Environmental Policy Act, NEPA, and we did, and we found some defects there and in the way that the administration set up the leases. So we suspended the leases, conducted further review, and ultimately canceled them. And of course, we were embroiled in federal court litigation right now. We won in the district court, in the District for Alaska, and now we're up in the Ninth Circuit. We are, following the law and preparing the NEPA documents to conduct a sale by the end of 2024 because Congress required it, and we'll be continuing to work on that through this fall. Another part of the oil and gas review called on us to, look at our nationwide program, and there was a slowdown in new lease sales that occurred, and it was not very popular with the certain members of Congress who insisted during the work on the Inflation Reduction Act that we speed up the work that we were doing and do more. And so what they did in that statute was tied offshore oil and gas leasing to wind leasing. And so we're not allowed to have a wind lease sale unless there's been an oil and gas lease sale in the preceding year. And so we're mindful of that in our planning process. And as I said before, Congress has got plenary power over the public lands, including the OCS, and they get to tell us what to do if they can pass a law that the president signs into law. And the IRA has a tremendous amount of money for infrastructure, for environmental improvements, for capping abandoned oil and gas wells, Huge amounts of that money has gone to Indian tribes, to red states, to places that desperately need work. We've got programs to train workers in order to administer these new programs to stop these leaks of methane and other toxic material into the atmosphere or into the groundwater. So a big part of our job over the last several years has been to continue to implement those statutes and just distribute this massive amount of money from the IRA and from the bipartisan infrastructure law that was passed before that. It's just, I've never seen anything like it, the amount of money that's available. We had to hire about 10 new lawyers to work on the implementation of the programs to just get the money out to the states and Indian tribes in a way that complies with other federal laws that govern, appropriations and expenditures. So that's been a huge part of our job. As a result of our federal oil and gas leasing program, we developed new rules through the BLM to reform the oil and gas leasing project under the Mineral Leasing Act to increase the bid price from $2 an acre to up to $6 an acre so that individuals and companies can't speculate unduly and tie up federal lands for years and years with leases that never get developed, but that hinders the ability to use those lands for other purposes, to call for increased reclamation bonding so that if a company goes out of business or decides to surrender leases, they have to clean up after themselves instead of leaving that bill to the taxpayer. And all of these things have been a success in our programs, and it's caused a lot of grumbling from those who were used to the status quo, but on we go. Another Alaska example of this is the National Petroleum Reserve rule. And this is, the National Petroleum Reserve is an area that was set aside by Congress in 1923 for, as the name would indicate, for oil and gas production, but also to protect special natural resources and habitat within the area. And that aspect of the NPRA has really been ignored up until our administration. And the jurisdiction was transferred from the Navy to Interior in 1976, and the conservation initiatives were shored up. But again, no real actions taken to give meaning to these important environmental protections and subsistence uses by Alaska Native communities that rely on this 23 million acre reserve and its resources. And just by way of reference, Colorado is, thank God for Wikipedia, 66 million acres, I looked up today. And so this is roughly 1/3 of the size of the whole state of Colorado. So we have the oil and gas development in the NPRA, and one of the most controversial things that we've undertaken was to approve the Willow Project development, which is within the NPRA. We took a lot of flack for that. Those, like it or not, the ConocoPhillips, which is in charge of the Willow Project, had leases. They purchased leases. They spent millions of dollars to develop those leases. They were issued those leases back in the Clinton administration in the 90s. If we were going to cancel them, we would have, by some estimates, a $9 billion fee to pay, money that we don't have. And Congress could do that, but it didn't happen. But as part of that approval process, we're allowed to require mitigation to make up for environmental harms. And one of the unique mitigation measures that we made was to lift up the Teshekpuk Lake special area. So the NPRA has got special conservation areas, and the Teshekpuk Lake is a huge area, about 1 million acres set aside for preservation for subsistence hunting and fishing by natives, wild bird reserves, and so we have made a plan with the willow proponents and with the native community of New Wixit, the tribal government there, and their native corporation under ANCSA to develop a conservation area, which is effectively a 1 million acre right-of-way established under BLM's existing regulations, which will allow the native community to control what happens in this 1 million acre area for as long as the Willow Project exists. So it's a really creative tool that was developed by our Solicitor's office teams as a way to promote conservation and provide mitigation for this oil and gas development project that was so controversial. We also developed a broader rule to provide more protection for the NPRA through public nomination of other special areas that might be set aside for conservation, all the while permitting oil and gas exploration, but with a thumb on the scale for protection. So again, doing what we can in aid of conservation under existing laws. So I'm going to quickly move on to two matters that are near and dear to the hearts of many here, the Colorado River, and an issue that I've worked on, the Columbia River. And they're really interesting. The Colorado River, we're dealing with drought, miscalculations in the allocation of water historically, and what are we going to do to deal with the shortages in the next planning phase, the post-2026 planning phase. And so we need to come up with a new plan for that. We're working on an environmental impact statement, an eventual record of decision that will set out how the secretary, who is essentially the river master, will operate the system. And of course, we always prefer that the 7 upper and lower basin states come to agreement on the planning, and is historically been the case. The states can't agree until maybe sometimes to the last minute. It's happened for the 2-year gap that we had recently, that we had to get by from 2024 to 2026. We got a little boost of snowpack one winter that helped, but the 7 states cut a deal on what should be the preferred alternative that we worked with them on and are implementing now. Sarah Krakoff is leading a team with the Bureau of Reclamation to develop the approach going forward. And we have to plan to do what we need to do in the absence of an agreement. It's really it's a typical you can't win proposition, because the 7 states they have a lot of meetings among themselves and they're cantankerous, but one thing that unites them is that they hate the Department of the Interior, or at least they say they do from time to time. And so I remember last summer, one month, I saw an article come across my desk. It was some of the state representatives were saying that Department of Interior is not doing enough. They need to be leaders on this thing. And the next month I saw another headline that said, they're moving too fast. What are they getting ahead of the states for? We should be leading this. And it just goes that way all the time. But, in these long, intractable natural resource disputes, you just have to stick with it, and you can't, when you work for the federal government, you can't take it personally when somebody attacks you, because it happens all the time, and they have to say what they have to say to protect their constituency. And, after all, we're the public servants, and, we're doing what we think Congress has directed us to do, and what our regulations and what our policy leadership tells us to do. And my office's job is to make sure we stay within the bounds of the law in all of that. And of course, These laws are ambiguous because Congress can't give clear direction. Although they insist on it, they deal with controversy and disputes by promulgating ambiguous statutes that then we are left to deal with as we administer these laws. But the big part about our Colorado River initiative this year is that we really have been including the tribes for the first time ever. So there are 30 Colorado River Basin tribes. The Commissioner of Reclamation has personally visited 15 of those 30 reservations to talk to those tribes about what they want out of a Colorado River management regime. And it's tough meetings, but tribes are at the table now. We've also convened a work group composed of tribes, states, and the federal government. So they're part of not just a one-on-one consultation with the Department of the Interior, but also with the decision makers from all three sovereigns that are engaged in discussion about management. Tribes are wanting us to model protecting tribal treaty-based water rights that are senior to everybody else. And so we're modeling different ways that reclamation can do that, all the while considering the legal aspects of what we're being asked to do. The tribal attorneys, like David Gover, have been extremely helpful, writing us, detailed analysis of what they think we should do. And it's really helpful to us to get these incoming letters that are just not, criticizing us, but also being constructive and saying, hey, we think your authority is this, and you could do this, you could do that. And it's really great, and it's something that David Getches had instructed me to do when I was starting out in my career and trying to get Interior to come over to our side to a case. David would always say, give them an exemplar, to write what you want them to say in a decision. And that was sound advice, and I repeat that for anyone who's interested in my views on how to approach the federal government in my office in particular. The Bureau of Reclamation, as a result of the Inflation Reduction Act and the bipartisan infrastructure laws, invested about $300 million in tribal conservation, in infrastructure efforts in the Colorado River Basin to promote tribal water use, to allow wet water to find its way to tribal communities who have so often been left behind, because the Bureau of Reclamation, historically funded non-Indian water projects, and also, if that wasn't an insult enough, they used Indian water to deliver it to the non-Indians, and there's a lack of equity that we have recognized and Reclamation has recognized, so we're doing all we can in that arena. A dark cloud on the Colorado River situation in the tribal context was, of course, the Arizona v. Navajo Nation Supreme Court case, where the Solicitor General's office on behalf of the United States denied the existence of any enforceable trust obligations by the United States. And the United States won that case 5-4 in the Supreme Court. At Interior, as soon as that came down, I had a talk with the Secretary and our Assistant Secretary for Indian Affairs, Brian Newland, about what it meant. And I said, look, it's been the position of the government and through the Solicitor General's office in the Supreme Court for many years that folks have not liked in Indian country. But it doesn't mean that we can't continue to negotiate with the Navajo Nation to provide a water settlement and to provide what they need as a matter of equity. And just yesterday, I read on my way out here the testimony that Brian Newland offered at a Senate Indian Affairs Committee hearing supporting the Navajo, Hopi, San Juan, Southern Paiute Indian water rights settlement. It's got a gigantic price tag, $5 billion. We don't say exactly how we're going to find that money, but it's it's significant that we were allowed to testify in support of that settlement. How it gets funded will be the next matter of consideration, and an extremely important one. And I think, and we were 4 years ago, John, you'll remember when I was down here with Mike Connor, and we had a meeting with Charles Wilkinson and Ann Getches and Bob Pelsiger about figuring out ways to institutionalize a permanent funding mechanism for Indian water rights settlements. And that's been something, the golden fleece that we've been chasing for many, many years. And that's a project that I've got on my mind for the first term of the Harris-Waltz administration, should I be around and should that happen. But it's a bipartisan situation. This money goes to states where Indian tribes are located, whether they're blue states or red states or purple states. And historically, Indian water rights settlements have gotten bipartisan support. So hope is to continue the momentum. We've supported a lot of Indian water rights settlements and will continue to do so. How am I doing on time? Okay. We started late, so I can go for a few more minutes. Columbia River has been, we've got the opposite problem. Flood control is what we're worried about on the Columbia River. And for years, the United States has benefited from a great deal we got with Canada back in 1964 when we gave them $60 million to build a bunch of reservoirs in British Columbia to hold back water to prevent Portland and other cities on the Columbia River from being flooded and washed into the Pacific. And that treaty is set to expire on September 1st of this year. And so we've been furiously negotiating with Canada. Like everything else, you wait till the last minute to get serious. So over the last 5 months, we had White House-led negotiations with the State Department, with the Department of Energy, and with DOI, because we operate the biggest dam on the U.S. side, Grand Coulee, and we also have huge Endangered Species Act issues on the Columbia River that have led to huge amounts of litigation. The good news is we were able to achieve at least a handshake agreement in principle with Canada to provide flood storage in Canada over the next several years so that we can maintain a reasonably certain structure for ensuring that tribal treaty rights and Endangered Species Act values are protected in the Columbia and Snake Rivers. So that was key. The other side of the ledger relates to the Columbia River federal power system. And so Bureau of Reclamation and the Army Corps of Engineers operate a lot of federal dams on the Columbia River system, including on the lower Snake River. And for years, tribes on the Columbia River, the Nez Perce, the Umatilla, Warm Springs, and Yakima, have wanted to remove those dams, but only Congress can authorize that. But the government, through my agency and through the Department of Energy and Army Corps, has not been able to develop an operating plan for that river system and a biological opinion that can pass muster in court. So since 2000, a federal judge in Oregon has been essentially operating that river under injunction. And the Trump administration, on the remand from their last loss in 2020, announced a new plan for operating the river, accompanied by a biological opinion from the National Marine Fisheries Service about how the plan would adequately provide for salmon, and the Fish and Wildlife Service for other endangered species under their jurisdiction. Of course, they immediately got sued by the tribes, Oregon, Washington, and environmental groups. And so we came into office and were approached by the tribes and the states. They formed a group. They called themselves the Six Sovereigns. They asked us to enter into negotiations with them to develop a plan that would look toward removing the lower Snake River dams. We said, well, we're not going to promote removing the lower Snake River dams without some additional study of, what are we going to do to protect the other stakeholders in the region. And those other stakeholders are those who use water behind those reservoirs for irrigation purposes. So we had to do a water supply replacement study if those dams are removed. Another component, that's largely the Corps bailiwick, would be to figure out a way to deal with transportation of goods from Lewiston, Idaho, the inland port, seaport that delivers grain down the Snake River to the Columbia and out to the ports at near Portland. So that's another component. And then those dams don't produce a lot of energy, but enough that it has to be replaced. And so how are we going to replace that energy? And so I actually worked on this one personally a lot, and I went to more meetings than I can count. But eventually, we were able to come up with an agreement to stay the case for 10 years while we do these studies and take another look at environmental compliance. It took the White House taking the lead. John Podesta got heavily involved, and we all traveled to Portland several times to meet with the tribes in the states about this. And it was really interesting because all my career I've read the cases involving U.S. v. Oregon, which was the United States suing Oregon because Oregon was so horrible in abridging Indian treaty rights to fish. U.S. v. Washington, more of the same, racism, shooting, arrests of Billy Frank and others. For years they fought that all the way to the Supreme Court. And here were the tribes in those two states now arm in arm, beaten on the federal government. It was a very formidable coalition and one that led to this stay in the litigation. And, on the energy side, BPA, Bonneville Power Association and the Department of Energy put $300 million on the table over 10 years to work with the tribes on having tribal clean energy projects developed to serve the Northwest and to facilitate the power needs of folks in Indian country and throughout the Northwest. So that was a huge thing for the administration. And a small but important piece of that was addressing the fact that, in its infinite wisdom, the federal government, through the Bureau of Reclamation and Army Corps, built the two farthest up dams on the Columbia River, Grand Coulee and St. Joseph. So we operate Grand Coulee, the Corps does St. Joe, and they built them without any fish passage. So it extirpated, all of the salmon runs that used to go all the way up into British Columbia. When folks asked, we've gone back and looked at it, there was very little study done. The tribal equities and the salmon equities were just not considered at all at the time. There's one little report by a biologist about that this is going to happen, but nobody cared. And so they want to reintroduce the tribes in the upper Columbia, want to experiment over the 20 years on seeing mechanisms to get salmon back up above Grand Coulee in St. Joe and into Canada. And we've been working with First Nation tribes, First Nations in Canada as part of that coalition. And so that is where BPA put $200 million on the table for conducting those studies over a 20-year period to investigate the feasibility of that. And so that would be the, if that's successful, it would lead to further efforts to implement a plan for reintroduction of salmon in the upper Columbia. So it's been kind of an exciting thing to work on. Well, I'm going to hang it up here, I think, pretty quickly, so you try to stay awake. I'll conclude, these natural resources battles go on forever. Tribal interests are always in need of attention. There's always litigation. We won a big case with the Indian country and the Brackeen v. Holland Indian Child Welfare Act case in the Supreme Court, but the court left open an important legal question about whether certain parts of the Indian Child Welfare Act constitute racial discrimination that violates the Equal Protection Clause of the Fifth Amendment, and that opponents are marshaling the resources to litigate that aspect. There's a case pending already in the United States Supreme Court. We have, I don't know if we filed it yet, but the Justice Department agreed to file a brief in support of the tribal position and the constitutionality of the Indian Child Welfare Act. The Public Lands Conservation Rule that I mentioned, we've got 5 different lawsuits filed in the last month. They've been consolidated into 3 different jurisdictions, one in Utah, one in North Dakota, and one in Alaska. I'm sure we'll end up with some conflicting results and probably end up in the Supreme Court, and the battle goes on. The Senate has gotten into some action with the National Defense Authorization Act, a bill that has to pass, and so that's always a great vehicle for getting pet riders on there that you want to deal with. And the Alaska Senate delegation has got a rider on there to authorize the Ambler Road that you may have heard of. It's a 240-mile road through pristine country, a national park, and BLM land in Alaska, and that had been approved by the Trump administration. We, as in the Arctic Refuge cases, looked at the record that had been developed and determined that it was legally deficient. And so we redid the environmental analysis, and for the first time, and this was Natalie Landreth from doing this in my office with our regional solicitor's office, reviewing the subsistence effects of this road. And BLM and the Fish and Wildlife Service did a bunch of studies and determined it would have very severe impacts and detrimental impacts on subsistence resources relied on by about 43 different Native communities. And for the first time ever, the BLM rejected a development project in Alaska because of adverse effects on subsistence resources. So we've been sued over that, of course. But there's this rider to reverse our decision. And as I said earlier, you know, Congress has got plenary authority over public land. So if this thing passes and Congress and President Biden doesn't veto it, you know, we're going to have to do whatever is decreed in that legislation. So there's never a dull moment. You know, I think I said at the start, we get sued over every action that we take. You know, I think the law students in the room and I guess we law professors can take heart in that, because it means that there's a need for lawyers and law professors too. So there's, and it's fascinating and important work, and it makes sure that the public can participate, not just in the administrative process, but in the judicial process as we go forward. So on we go. I have not even talked about the Supreme Court's recent decision doing away with Chevron deference and whether that's going to mean for us. For my part, you know, I've spent a lot of time suing the government, and I would complain about Chevron deference when I was on that side of the V. You know, I think we got the court's decision, and it's going to be up to my team in the solicitor's office to work with the bureaus to make sure that when we develop regulations and interpretations of statute, that we can make the case that our interpretation is the best interpretation. And we're not going to get deference on that. And of course, the court will give deference on application of facts to legal standards and so on. So it's not, hasn't done away with everything, but that'll be a change. And you know, there are several other important administrative law decisions that came out of the court last term that are going to change the balance. So in closing, I'd just like to thank CU for inviting me out here. Chris, thank you for everything in the Getches-Wilkinson Center, and thanks to the students I got to meet with last night. and to have lunch with today, for allowing me to come out and spend time with you. I think there's probably 3 people I know that are watching this on live stream anyhow. And my wife and my daughter are 2 of them, and somebody in D.C. So I want to express my appreciation and admiration for Secretary Holland and the rest of Team DOI for all the work that everyone does and how we collaborate. It's really a fun place to work for me, whether it's with leadership in DC or with our regional teams in my office. And, for my part, I really want to thank the tremendous team of career lawyers in the solicitor's office who work tirelessly and for their entire careers to advance the cause of sound public land and resource management and to fulfill the government's treaty and trust obligations to Indian tribes. So thank you, folks, and thanks to NARF for getting me started on this. I'm really glad CU is here and has such a great natural resources and Indian law program. So it's a real pleasure to be here, but I'm happy to take questions, or I'm also happy to go out and relax in the lobby. But Chris, I'll let you do what you want.
Thanks so much, Bob. I think a lot of us have felt that the administration has gotten a lot done in the last 4 years, but it's amazing to be able to hear an inside perspective on truly how much you and your team and everybody in the administration has accomplished. It's quite remarkable. So let's see, Zane is back there with the mic, and we're happy to take a couple questions if folks have any. This is a really unique opportunity, so I encourage you all to jump in.
What brought about this focus on Native American rights, and particularly around water? Was it a cultural change or policy or people?
Well, I think it was a couple of things. It's been the persistent litigation over the years where tribes have been mostly successful in obtaining legal victories in court that get translated into Indian water rights settlements. And NARF has been a big part of that, along with a whole bunch of lawyers here in Boulder. But I think it's also, for our administration, it's Secretary Holland, saying, hey, we're going to support the tribes. And as I said at the start, she is not just an ardent conservationist, but also an ardent promoter of Indian rights, and that has just had a tremendous influence on all the political appointees, of course, because they want to make her happy. And they have to make her happy. We all work for her. But also, I think the career teams see, what the client wants to do, and, they serve the client. We all do as lawyers. So it's been that on our side. And I think the tribes have been just tremendous advocates. They're coming out to meet and insisting on, the government's recognition and enforcement of their treaty rights and the equity involved in enforcing the trust responsibility.
Thank you. Very, very interesting talk. I listen to a lot of country and Western music, and I'm always impressed by the hundreds of songs and hundreds of thousands of words they remember. And I'm equally impressed with all the facts that you have and have related to us this evening. You sure have a lot on your plate. Inflation is a real problem in this nation. Everything seems to be going up and up and up. But there are a couple of things. There's only one thing that I can think of that hasn't gone up related to the Department of Interior. Do you know what that might be that I'm alluding to?
I don't.
I'll give you a hint. Beef prices have gone up 500% in the last 45 years. Does that trigger something?
Okay.
AUM grazing rates. They haven't moved a bit from the time Reagan established $1.35 per AUM back in the late 70s. And cattlemen are very entitled and are paying a fraction to lease federal land for grazing as they would have to pay on private land. What are your thoughts on that?
Well, that's an issue that, we haven't bid off. I was working for Secretary Babbitt when he attempted to do some real reforms to grazing. And I remember it was like my first week on the job going over to the White House, and there were all these West Denver Post and all these other newspapers talking about the war on the West that Secretary Babbitt was undertaking and underwent some modest reforms. So that's an area that is really important. I don't have much to say except that it needs advocacy to get movement in any administration.
Yeah, so reflecting on the 10th Circuit oral arguments that a lot of us watched in this courtroom this morning, and just thinking about how shifting presidential administrations have led to, for example, such big shifts in national monuments in the state of Utah, how, if at all, have your priorities kind of shifted in these last few months of the Biden administration?
Well, I mean, we've designated several new monuments, some small ones, most historical monuments in the last few months. One of the things that we were asked to do immediately when we came in was to look at Grand Staircase and Bears Ears, and to also consider not just restoration, but also to consider expansion. And I worked very closely with my team that works on monuments to ensure that we had developed a record in the proclamations that would be defensible under the Antiquities Act. And we still think that landscape monuments are, since having been approved with Grand Canyon by the Supreme Court early on, that those are perfectly fine. But I also believe in developing a record, which is not hard to do in these really rich places, that there are natural resources in every speck of that area, that large landscape, and cultural resources that are worthy of protection under the Antiquities Act. And if you read those proclamations, they're extremely detailed, and the work that we do is closely done with the Justice Department to ensure that we've got a record. So if there ever is a searching review of the merits of these proclamations, that we'll have a record that's legally defensible. So we just continue to do that. I think another important part of the Antiquities Act implementation is that, it's not just done in Washington, D.C. with somebody sitting around drawing lines on a map. It's, there's community engagement that takes place. If you look at the recent monuments, there's maybe people who object to them, but there's always solid community support in the region for these. And we have hearings out there to hear from folks before we make a recommendation that a particular area be designated as a national monument. And that includes, because they have plenary power over public lands, consultation with local congressional delegations. So it's all part of a strategy of inclusion and consideration and consultation with local communities.
Okay, thank you very much. So I'm from Ghana, and barely 8 weeks since I had my baptism into natural resource and environmental landscape of the U.S. So I want to thank you very much for giving me an insight in like 10, 15 years what's been happening in that landscape. But I have a question. Looking ahead, say to the next 10 years, what do you think will be like the policy direction or technological innovations that will be required within the natural resource and environmental space to make it more attractive to new lawyers and then to preserve and conserve the environment?
Well, I think, there's an inevitable trend toward development of clean energy and a movement away from fossil fuels. I think it's not going to be immediate, but it's a trend that's definitely on the uptake. As these companies are in business to make money, and we see major oil companies coming to us to talk about, carbon sequestration. Is that a thing that will really work? And so we need to continue to look at the science behind that and do some experimentation in that arena. And I think that, this offshore wind industry continues to be a big thing. There's just boundless opportunity in those arenas, but also, in my own favorite natural resource area, water law, there's this myth that you're going to have a lawsuit and you're going to have finality in a water rights situation. It's not going to happen. It's never going to have finality. Everything needs to be revisited continually. You might have a moment in time where you've got a new baseline set out about what the relative water rights are, but there are always going to be changes induced by, climate differentiation as global warming continues inevitably for the immediate future anyhow. And so management of the Colorado River is always going to be a thing, as we say. And likewise, the Columbia River and other major river systems are going to serve different constituencies and different purposes as time goes on. So there's always going to be a huge amount of work in those arenas. We've got more people all the time and finite resources, so that leads to disputes in the policy realm. And Congress never keeps up with laws that that they could implement using their plenary authority under the Constitution, because it's too hard. It's really hard to be prescriptive on the national level for these things. And so they're going to have laws that are somewhat ambiguous and need to be implemented. There will always be a Republican or a Democratic administration, and depending on whose ox is getting gored, there's going to be lawyers on both sides advocating for the government to do certain things, along with industry in their legal counsel. So I think it's a rich field. It's very rewarding. I can't think of having done anything else I would have wanted to do with my career except work in Indian law and natural resources law, and I encourage all the students to do the same if they have that interest.
We have time for one more question. Vanessa, did you want to jump in with a question?
I love how you ended that, though. Thank you for the wonderful presentation.
Yeah, it's a huge problem. So many of these geothermal projects are in the vicinity of sacred sites or important cultural areas for tribes. And the way to navigate that is to work with the tribal communities on the part of the department and make the best decision. The same with the wind. We've had tribes now in Oregon have sued us over offshore wind sail out there that's scheduled to come up fairly soon. I don't think they've filed a PI motion yet, but I just read that complaint yesterday. We've had them on the East Coast, and I mean, the secretary, has got the answer. Her answer to this, which I agree, which I subscribe to. I'm her lawyer, and she's the policy leader. She's says, look, this climate change is real. It's a thing, and we need to come up with solutions that involve clean energy and different interests. Have to get on board to help do that. And you know, I don't like it when that's a tribe that doesn't like it, and you know, so that's our job, is to work with them to come up with mitigation for harm that they feel is going to be caused by a project. But it's one of the most unsettling things that I work on in the office, and that we feel as we navigate this transition to clean energy. So.
Hey, I think that's it. Thank you so much, Bob.
All right, thank you.